The case is now being recorded.
Thank you. Good afternoon, everybody. So welcome to the Zoom continuation of the session of this court. We've heard 5 cases already in court, and this is the last case of the day. We're hearing it on Zoom. Despite the fact we're on Zoom, the same rules apply as usual, 15 minutes per side. I understand that the appellees are splitting their time 7.5 minutes each. We've read your brief, so you can go right into your arguments. Let me ask you, too, that since we're on Zoom, when you're not speaking, please mute yourself, but remain on the screen so we can know you're still here. And at the same time, since we can see you, please keep reactions and gesticulations to a minimum because that can be distracting. So with that, I'm going to call this case, last case of the day, which is DCF versus Father, 22P475. And we'll hear from counsel for the father, which is Attorney Chenevert, if I'm saying that right.
Thank you, Your Honors, and may it please the court. My name is Dana Chenevert, and I represent the father, who is asking for a remand so that the lower court, can give full consideration to the permanency plan that father proposed or put forward at trial. But the primary assignment of error the father sees with the proceedings below is conclusion of law 40 and finding of fact 179, where the court found that father's proposed plan of placement with the paternal grandmother was never formally nominated and lacked sufficient content or substance for the court to even consider the plan. And then the findings reflect that the court did not, in fact, consider the plan. And that is that course of action, father posits, is inconsistent or unsupported by precedent. So just as a general matter, the court does not define what formal nomination means, but there's a reasonable inference that the court is referring to the fact that father's plan was not written. And the reasonable inference comes from the fact that the only difference between DCF's plan and father's plan was that DCF's plan was written. DCF's father's plan was put forth at trial and supported by testimonial evidence.
The reason I can't find father's plan in the appendix is because there is no written because it doesn't exist.
There is no written plan. That is correct. But he did put forward that plan at trial, and the paternal grandmother, which was his plan, testified at trial. And so the evidence that exists in support of that plan is in the form of paternal grandmother's testimony.
So
now,
is it father's burden to bring forward evidence that the grandmother or whatever his plan is would be capable of fulfilling the child's needs?
If I understand the question, is it father's burden to bring forward a written plan, Justice Henry?
No, not a written plan, just that he bring forward enough evidence to show that his plan is realistic and appropriate for the child.
I would posit that that is father's responsibility, and that father actually met that responsibility at trial through the testimony of his mother, who...
Well, but we're going to hear in a minute, I predict, that the grandmother was not an appropriate placement because she believed the biggest problem with the parents' situation was that they had a housing problem and that they really never got a chance. And she didn't have any concerns about the father's ability to care for the child and minimized his anger, domestic violence, and the mother's substance abuse. So what do you say to that? And therefore that really made her disqualified. So what do you say to that?
Well, I'd say to that that's not DCF's primary argument. DCF's primary argument in their brief was consistent with the trial judge's findings, was that the evidence, there was not enough evidence, there was insufficient evidence to even consider whether she was an appropriate placement or whether she could provide the environment to meet or provide the appropriate environment and meet the child's needs. And I would say that father did present through her testimony sufficient evidence, or evidence that could have at least been considered, right? We're going back to the fact that the court didn't even consider it because the plan wasn't written, and that the court should have done that. because there is evidence that, you know, of her employment. It's at father's brief at pages 9 through 15. I don't want to, you know, waste the court's time just sort of regurgitating what I wrote in the brief, but, you know, we do have evidence of her employment. And during a course of that employment, she had to go through an FBI background check, a Corey background check. She went through fingerprinting. We had evidence
Does that
that she
assume that the judge credited that testimony?
Sure it does, because if the judge doesn't credit it, sure, right? But
Right,
there's
but
no evidence.
I guess I was left confused because often when you go through a security review like that, a bankruptcy would be concerning because it might make you vulnerable to being bribed, right? Because you have a financial need. So it seemed like the testimony might be a little inconsistent on this point.
Well, to that point, there's no finding that the court discredited her testimony. The findings do not reflect any consideration of that of the paternal grandmother's testimony at all, that she was employed, that she had been employed, that she had you know, sufficient housing and room for the child. You know, one of the arguments of DCF was that, or actually, in addition, there was insufficient evidence. There was evidence that she had place in her home. She owned her home. She had room for one more person, and that she wanted her grandchild to be with family.
Could the judge?
Go ahead.
Could the judge base her finding that the plan involving the paternal grandmother was not fully developed enough on the grandmother's testimony? For example, at page 1946 of the transcript volume, when they took your granddaughter, did you put in an application for her to be her caregiver? No, I did not, because I never thought this would happen. They should have given her back, and that's what I thought. I've never been in a DCF type of thing to know that this situation would ever happen to a child. So could the judge infer from her testimony that she was in denial about the parents' unfitness and hadn't stepped forward and was evasive when asked if she'd allow her son to live at her home?
Wow, Justice Grant, with all due respect, there are a lot of assumptions in that question. The fact that the paternal grandmother was evasive, there's no finding as to that fact. The fact that, you know, could she infer, you know, the basis on which you're asking whether this judge could infer from the testimony, there's no findings indicating that she inferred anything. There's no findings.
So, but you're saying the judge should have credited her testimony that she had a job in a home, but should not have weighed her testimony that she had room for one more person, and she wouldn't say whether she would allow the son to live in her home.
I think the argument is that the judge should have considered it and any of it. And there's no indication that she credited or discredited, made inferences or didn't. There are no findings as to the suitability or as to the credibility of paternal grandmother's testimony, the suitability of her as a caretaker for the child, or her ability to meet this child's needs by providing stable housing or providing, taking her to doctor's appointments. There's testimony that the child had some special needs. Nothing as to the relationship. There's nothing. So I think
was there testimony that the grandmother was had knowledge of and could meet the child's significant needs?
There is testimony from which the lower court could have inferred that yes, the paternal grandmother was familiar with the child's special needs. What's
the citation for that?
Well, it has to do with the visits, and I can provide specific cites to the record and a post-argument letter, or I can look at it right here, whichever you would prefer. But paternal grandmother, there is a documented history or in the record of paternal grandmother having been there at the time of the child's birth, having provided support throughout the for the father throughout the proceedings, having attended visits, I believe the specific site said that paternal grandmother had attended 3 or so visits with the child, and that she had run father back and forth with the child to doctor's appointments. So I can provide cites to those records, those facts in the record. But there is evidence there where the court could have inferred and chose not to, that, paternal grandmother was in a position to be able, she was familiar with what the child needed and could meet those needs.
Well, she was testifying that at the time of trial, she was still working full time, right?
She was.
And at the time of the child being first removed, she said she did not have the ability to meet the child's needs because she worked full time and was unable to take time off frequently.
That's correct. But she did say that the only barrier, she didn't know how she would do it because she didn't have daycare. And daycare is a service that DCF regularly provides to foster parents, or, to parents of children, or to substitute caretakers of children routinely. So if DCF were really interested in working with this paternal grandmother, this family member, to be able to keep this child in a kinship placement, they could have very easily addressed that concern of the grandmother, and they chose not to, for reasons I can't speak on those. I could speculate, but I can't speak on those.
Well, couldn't it be that the judge didn't take the father's adoption plan seriously because it wasn't offered seriously? That it kind of looks like sort of an afterthought. And in fact, when it's introduction, I'm not sure if she's testifying because, in terms of in favor of keeping the child or an alternative resource. I mean, and, as you said, there's no written plan.
Offered seriously. So just because a plan, and this is DORA, which was decided by this court, and also underscored in Varick and cited to in Zarissa, is that, basically a late offered plan, even at the time of trial, does not make it not serious. I hear what you're saying, Justice Massing, that perhaps the lower court could not take this seriously because it wasn't written and it was offered at trial. But there is no requirement in the precedent of this court that requires the plan to be written. It just says that it needs to be supported by sufficient evidence, which could be trial evidence or documentary evidence, and that a parental nomination, it doesn't say that it has to be written, but a parental nomination shall be considered when determining which plan furthers a child's best interest. And father posits that the lower court in this case erred by not following the mandate in DORA that's supported by Varick and Varissa, which is a Rule 23. But, citing the published case, that the court was under obligation to consider the plan, notwithstanding when it was entered, and then, or when it was offered, and then also if it needed to take additional evidence, that it should do that, right, before making a decision on which plan furthers the child's best interest. And the court didn't do that either. This case went on for 20 some odd court dates, and there was an ICPC. There was a previously court-ordered ICPC, and paternal grandmother's formal application to DCF was pending. And I wanted to note for this court that the timing of that application, it went in the very same month that the Department of Families filed their notice of intent. I believe that was September 2020. And that supports the grandmother's testimony that she didn't realize, because she had no experience with DCF. And I think that's a good thing. She had no experience with DCF and did not realize that they were actually going to take this child, that they were actually going to adopt this child out.
I was just a question. What's an ICPC?
Oh, sorry. I'm sorry for using that. It's essentially a home study. It's the pre-adoptive home study that would have given the court the information that it needed to be able to make a fully informed decision on which plan furthered the child's best interest. It would give information about the makeup of the home, who lived in the home, how the home was set up, Was it ready? Were there safety concerns? Was there any, was paternal grandmother ready, willing, and able to take this child into her home? So we did.
Did her husband join in that application?
I believe he did. I need to verify that, but I believe that he was on the application the formal application when she submitted it at September 2020 at the time of the filing of the notice of intent. But I'll verify that for this court. So I see my time is dwindling. And so what we would ask this court to do is remand it, to require the lower court to at least consider the plan, not necessarily make a finding that it was in the child's best interest, but under DORA, require the court to consider the plan and take evidence. Thank you very much. If there are no further questions, I would rest on my brief.
Thank you. We'll hear from, I guess we're hearing from the department first, Attorney Kernan.
Thank you, Your Honor. May it please the court. Jennifer Kernan for the Department of Children and Families. This court should affirm the juvenile court's determination that the department's proposed plan of adoption by her pre-adoptive family served the child's best interest. And before I get too deep into the argument, I just want to take a moment to address Justice Massing's question regarding the ICPC. An ICPC is an interstate compact on the placement of children. It is, as Attorney Chenevert mentioned, a home study, but it's used to effectuate a home study out of state. Here, I did not recollect that there was an ICPC or any sort of out of state involvement. So I just wanted to clarify that. It is true that grandmother's home study with the department was pending at the time of trial.
So it didn't seem like the department was moving with any urgency around grandma.
I disagree with that classification. I think the testimony from the adoption social workers indicated that they had received grandmother's application and that there were a couple outstanding matters, one of which was to speak with grandmother's husband, who, if grandmother was looking to adopt and they are married, her husband would be required. I believe that's JLC 210 section 1, and that is cited in my brief if I misquoted it here. So the department had explained to grandmother, and this is testimony, I want to say on transcript around 1898, but I'm not 100% certain on that. But there was testimony from the worker that the conversations with grandmother indicated, and she actually told grandmother that we need to speak to you and your husband about this to see that he's on board too. And the testimony from the worker was that they were waiting for grandmother to get back to them in terms of her husband's availability. So I don't think that the evidence indicates that the department was delaying or frustrating grandmother's home study in any way. Does
this answer Justice Henry's questions from before? The grandfather was not on the application?
It's sort of a hard question to answer with a specific yes or no. I think at one point at the initial application, he may not have been included, but there is a suggestion in the record that at some point he may have joined that. I don't know whether he continued to stay on that application or not. And sorry, that's not a simple answer. Here, the court was correct when it determined that father's proposed plan lacked sufficient content to enable the court to fully consider it. A plan is sufficiently detailed when it provides enough information to allow the judge to evaluate the type of adoptive parents and the home environment proposed and consider whether the proposal is best suited to meet the child's specific needs. And at this stage of the inquiry, it's the specific child's needs. We don't get to best interest yet until the court has determined that the proposed plan has enough information for the court to say that, okay, yes, this plan can meet the child's needs.
But it does seem like we're not looking at the one sentence that DCF offered. Because you presented a lot of evidence about the placement, right? So right. You would agree with Attorney Chenevert that we wouldn't just look at the father's assertion, we'd look at what evidence he put forward.
Yes, I think That's
Yeah.
completely fair. Yep. And Attorney Chenevert addressed the fact that the court mentioned that there was no written plan that father presented. And a written plan is not necessary. But what is necessary is sufficient detail for the court to be able to say, okay, yes, I see how this proposed plan could meet the child's interest. And what constitutes sufficient detail is going to vary depending on the needs of the child. And here we've got a child with very specific specialized needs, medically as well as emotionally. The court noted that the child had been born substance exposed and requires consistency, structure, and a lot of nurturing. Child is physically and emotionally high needs who requires more care and attention than the average child her age. Additionally, she requires constant engagement in physical therapy through play and strict compliance with the boots and bars on her legs. And your honors are likely familiar that was to correct and help stabilize her foot after surgery. The child also experiences aggressive and self-harming behaviors following interactions with mother and father. There was nothing contained in father's presented plan or just any of the evidence that showed how grandmother would meet these specific, not quite extraordinary, but certainly above average needs of this child. And that in part is why the court was correct in asserting that father's plan lacked sufficient evidence. And because father's plan did not pass muster, did not sort of pass that first stage of demonstrating that grandmother could indeed meet the needs of the child, the plan does not get to pass on to the next stage where sort of the weighing between the plans and the assessment of whether or not each plan meets child's best interest. And there was limited information that father presented through grandmother's testimony, such as grandmother's employment and work. But that limited detail did not suffice to indicate in any way how grandmother would meet this child's needs. And if there are no further questions, I will rest on my brief for the remainder of the argument and ask that this court affirm the decrees below.
Seeing none, we'll hear from Attorney Kruger then. Unmute. You have to unmute now. How many times have we said that in the last 3 or 4 years?
Okay, is that better?
Go ahead.
Good afternoon, Your Honors. Yvette Kruger here to represent the child. We've heard a lot about filing a plan at at late notice, but I think it's important to consider the best interest of the child and the amount of time that this child has spent in DCF custody. The child has been in DCF custody her entire life. She was nearly 3 years old at trial and is now 5. Father presents no reason to harm the child by further delaying her much needed and deserved permanency and stability with her pre-adoptive parents and family. The child requests this court affirm the trial judge's decision for 3 main reasons. First, overwhelming evidence supported the judge's conclusion that adoption by her pre-adoptive parents is in her best interests. This court, I'm sure, is very familiar with all of the child's needs, behaviors, treatment for her club foot and surgery, her dietary needs. But what is important to remember is that she calls pre-adoptive parents mom and dad. She goes to them for safety and reassurance. She is strongly bonded to the entire family, and she doesn't know any other family. The trial judge concluded that removal from this safe and stable family would result in a traumatic loss for her, particularly if exposed to the parents, where she evidenced such aggressive, harmful behaviors to herself. Most notable, however, in this case is the exemplary care, attention, and patient nurturing with which the pre-adoptive parents have seen to every one of her significant physical, medical, and emotional needs. It bears mentioning.
I'm sorry to interrupt, but that's not really what the father's saying, though. I mean, the father's not contesting that the adopted parents are a good option. He's only saying that his wasn't considered.
Father's also asking for more time. He's saying, I agree, he filed this 11th hour, rather empty plan of grandmother testifying, saying, I'm here, ready, willing, and able, but with all kinds of uncertainty about room, whether father's living there or not. And importantly, while she filed an application in September of 20, she was on notice in January, father was on notice in January in 21, that DCF was still waiting to hear about the husband's availability to discuss whether he was in support of adoption and whether they both understood what that meant. And with regard to the home study application, DCF counsel informed the court on February 23rd at 118:61 of the transcript that both grandmother and husband had filed an application for a home study, but it was incomplete. We are now within days.
The application, you mean, was incomplete?
The application was incomplete and was waiting for documents.
And what was the record site for that?
1861. So we are now within in a 23-day trial. We are within a couple of days of the end of trial. Paternal grandmother testifies on the 19th day of trial and is wholly, let's say, unprepared to discuss the meat of the matter, not just the preliminary, don't go past go, did you file a home study, but can you actually take care of this child? I'm going back to the pre-adoptive parents because I think this context, the great care that they have provided her, how in every way is a sizable task, that they have done it in an unmatched fashion, and that this child.
Do we have a copy of that application in the record somewhere, or is it just the references to it in the transcript?
It's the reference in the transcript. So I do think that the tremendous care the pre-adoptive parents have given is relevant to father's request for more time. Father's plan is rather barren, and thus all of the time that would be required to establish whether the husband is in fact in support of adoption, whether she can house the child, whether she can care for the child's needs, and take the child to the 130 appointments as the pre-adoptive parents. I mean, this is relevant to fathers. It's not simply the judge didn't decide, the judge didn't view it because it didn't pass muster. I'm discussing the great care she has because it's the best interest of the child who deserves permanency and stability. After all, that's what we are here about. And the 11th hour attempt at presenting grandmother is severely lacking, not only in the preliminary information, but critical in this point. And as you've already been discussing, there's absolutely no evidence she has any understanding of the child's needs. I disagree with father's counsel, that, attending 4 visits or 3 visits in 2020, she has an understanding of this child's constant need for constant reassurance and touch and hugging, and that she has aggressive behaviors, and that needs to go to surgeons and orthopedic shops and dentists and ophthalmologists and et cetera, and developmental specialists. So in addition, there's absolutely no evidence that grandmother and her husband have any relationship with the child, that they know the child. Grandmother only knows that she wants her to be with family. I don't think there's in the record where she says, I want to adopt this child. I think perhaps there's some leading question by her attorney. You want to adopt this child and you love her, right? Yes, of course I do. So, as in adoption of Varick, this lack of information is fatal. And as in adoption of Lars, a sufficient plan here that passes muster must show that the adoptive parents have knowledge of and experience with the special needs and are capable of meeting all of the child's needs, intervening and dealing with severe behaviors, and be able to advocate for the child. And thirdly, if I have enough time, I don't see how much time I have left.
Actually, your time is just elapsed. So I think we understand what your argument is. Are there any other questions? Okay, so we will leave it at that, and the case will be submitted. So thank you all for participating in this. Our Zoom actually went pretty smoothly, and have a great weekend.
Thank you.
Thank you.